Welcome to the Appellate Division First Department. We have over 6.5 hours of argument time requested, so only ask for the time that you need, not the time that you wish. If we have questions, we will continue to ask them. People versus Jose is submitted. Robinson versus Hyatt, appellant. How much time are you requesting? Respondent? Oh, is there anyone? I'll give you 5 and 5. L. Anthony, appellant, is submitted. IGS Realty versus Brady, appellant. Respondent? 4, 1, and 4. Rodriguez versus 167 LLC, there are 2 cases, but they're going to be argued together. There's not going to be separate time for each case. Appellant? Respondent? 5, 2, and 5. People versus Anderson is submitted. Owens versus New Empire Corp. Appellant. How much time are you requesting? Respondent? 5 and 5. People versus Brady is submitted. John versus Maria, appellant. Five, 1, 5, and 4. United Medicine and Rehabilitation, appellant. Is respondent here? Do you wish to submit? Okay, you can have 3 minutes. Solomon versus 360 East 72nd Street, appellant.
4 and 1, please.
Respondent. 4, 1, and 3. People versus Moultrie, appellant. Respondent. 5, 1, and 5. Bridge Cavalry Fund versus Sharico, appellant. Respondent. 6, 1, and 6. Windermere Properties versus City of New York, appellant.
Good afternoon, Your Honor. Appellant requesting 10 and 5, please.
Respondent.
Respondent, 5 minutes, please.
6, 1, and 5. TD Bank versus AH Dental, appellant. Do you wish to argue or do you want to submit? Is there a respondent here? No.
I'll argue, but 5.
I'll give you 3 minutes since respondent is not here. People versus Lewis, appellant. Respondent. 6, 1, and 5. So the first case being argued today is Robinson versus Hyatt.
Hey, how's it going? May it please the court. My name is Alan Messina, and along with co-counsel Richard Washington, I represent the appellant in this matter, petitioner Terrence Robinson. This appeal presents 4 critical questions that strike at the heart of civil service protections for employees and the integrity of administrative proceedings. Mr. Robinson served NYCHA with distinction for 13 unblemished years before being terminated based on fundamentally flawed proceedings, Your Honors. The determination suffers from 4 fatal defects, each independently requiring reversal. First, a clear violation of the mandatory 18-month limitations period under Civil Service Law section.
Why isn't it timely? Under Mikuleski, the relevant measuring date is service of the first set of charges and specifications. And if we use that date, why aren't the charges here timely based on that date?
Understood, Your Honor. Respondents rely heavily on Mikuleski, and Your Honor, arguing that the service of charges controls the limitations period. But Mikuleski is distinguishable because the case involves determining which set of charges governed when multiple charges were served. The court stated that the relevant measuring date is service of the first set of charges.
Why isn't that dispositive?
Well, but in this case, Your Honor, in the context of determining, I'm sorry, but in respondent's interpretation, Your Honor, would render the statute basically meaningless. Employees' protections meaningless if an agency can serve charges within 18 months and then delay the hearing indefinitely.
Well,
Was the delay due to his failure to get a COVID vaccine?
Well, Your Honor, again, that's not part of the statute. There's no carve-out for that delay. It's still not part of the statute. Therefore, that does not apply in this particular case.
Right, but as long as it's within 18 months, which it was if you follow Ms. Mikuleski, then the reason it was delayed was not because it wasn't timely brought, it was because of his failure to get the COVID vaccine. So why should that be a basis for overturning the determination?
Again, Your Honor, I think the statute is very clear that there is no, that there's no carve-out for this particular delay.
But this
What do you
statute
mean by
doesn't.
carve-out? I'm sorry. What do you mean by, I'm not really understanding what you're meaning when you say a carve-out. It is 18 months. It was brought within 18 months. So what are you referring to when you say a carve-out?
Well, Your Honor, we disagree. It was not within 18 months, Your Honor.
Is it your position that because the hearing wasn't held within 18 months, that means that it was not brought within 18 months?
That is correct, Your Honor, because that is not the definition.
Is that how the case law interprets what it means to be brought?
The proceedings would begin at the time that testimony and hearings were taken, Your Honor.
What in administrative law or the CPLR says that? Normally, for example, under the CPLR, an action begins when the complaint is filed, not when the trial begins. So why would this be any different, that the service of the notice of charges is the point from which the 18 months backwards to the most recent event is how you would measure it?
So we have it measured, Your Honor, it's 26 months after the alleged misconduct,
Until what?
until the hearing began, Your Honor.
Right, I understand. My problem is, why do you think it's correct to measure it to when the hearing begins as opposed to when the notice of charges is served on the person?
Your Honor, we believe that the statute, Civil Service Law, Section 75-4, could not be clearer. It provides that no disciplinary proceeding shall commence more than 18 months after the
But
occurrence.
commence normally means when the beginning pleading is filed, as it is in the CPLR. An action begins when the complaint is filed, not when a trial begins.
And then we would point, Your Honors, to the matter of Wojciechowski versus O'Neill, 295 AD, 2D 670, is directly on point with this particular matter. The third department held that wrongdoing forming the basis for charges must occur within 18 months before commencement of this proceeding. The court measured the time from when the hearing actually
We always measure
occurred.
commencement of proceedings from the service of a pleading.
Well, again,
Why should this be, by what reason is this different?
we rely on the matter of Wojciechowski, Your Honor, which indicates that it measures it from the time from when the hearing actually occurred, not from paper service.
Thank you.
Thank you, Your Honor.
May it please the court, Alexander Lloyd for respondent, Lisa Hyatt, chairman of NYJA.
So, counsel, are we misinterpreting the word proceeding wrong then? Because if, based upon the argument made by your adversary, that the proceeding is actually the hearing and not necessarily anything else.
I don't believe you are. I think that the proceeding initiates when the pleading document is served, when the charges were served, and both the first charges and the amended charges were served within the 18 months. The only delay here is actually was caused by petitioner for his refusal to get the vaccine. So if it's determined that it's untimely in this instance, it would actually be rewarding petitioner's bad behavior and allowing him to escape punishment.
I mean, it's sort of basic that in all areas we measure, this time period is measured from the service of a pleading. The only exception to that may be speedy trial context where you're concerned about when the trial starts. Just wanted to ask you something about something that your colleague said, that he had an unblemished record. What were the 21 counseling memorandums about?
So they were about similar instances: insubordination, refusal to follow directives, failure to complete assignments, time and attendance issues. It's a complete misrepresentation that petitioner had an unblemished work record.
Thank you.
Thank you.
Thank you both. RGS Realty versus Brady.
Hello. First, I want to thank you very much for giving me an opportunity to make this appeal today. The First Department case law on page 22 and 23 of appellant's brief states, lower courts cannot disregard stipulated facts in the absence of compelling reasons to do so, and that the trial courts must respect stipulations made during discovery, including depositions, unless there is evidence of a mistake or fraud. I went back to Judge Coates with a stipulation from May 4th, 2021, where Mr. Shiland and his attorney, both attorneys, stipulated that the document speaks for itself. It says nothing about personal guarantees. That's admitted. We can stipulate to that so you don't have to worry about it.
Was that motion brought 3 years later?
It was actually several things before then. I started off with in the federal courts trying to have something done, and it's been sitting there. And I did go to Judge Ostriger, who was the Judge Ostriger, the attorney himself, in November of 2023, asking him to address it, and he retired at the end of 2020. In November 23rd, 2022, and he retired at the end of 2023 without ever addressing it. And I know that there was a filing injunction, and then and I'm not an attorney myself, but I was able to figure out that maybe there was a way of doing it as a because it was a defendant, so I didn't have a filing injunction on me as a defendant. And the judge in his decision never said anything about this being untimely, nor did Mr. Shiland ever make that claim before his brief. So it made it that the filing injunction, in other words, his stipulation proved that it was fraud and misrepresentation, that he used that cheat to force the sale of my business and my livelihood, and it's amazing, destroyed my life in so many different ways. And he knew that it never pertained to the personal guarantees. And if you look at page 304 of the record, it states what the landlord's claims were. So his only claim was pertaining to personal guarantees, only claim. So the landlord could never have been the prevailing party because the claim wasn't even on the jury sheet.
Are you done? You have another minute if you want.
Well, that's the primary thing. Also, there is something. I mean, just kind of give you a visual picture of it. 2 years later is when Mr. Shiland made the false claim that I lost, and he used this jury sheet, and they concocted the story that it meant the jury ruled in the landlord's favor and against his counterclaims when that was not the case. And he repeated this, and that's exactly what he wrote exactly in the judgment, was that a jury ruled in IGS' favor and against my counterclaims, and at a stipulation, he admitted neither were on the jury sheet. The landlord's claim and my counterclaims, neither of them were on the jury sheet. And the only line that he ever used was that it was the script, and he stuck with it through these different things, was to say that the jury unanimously ruled in the landlord's favor and against his defenses. And it even got worse when he made his petition to Judge Goetz. All of a sudden, if you would please look at page,
I'm
when
going
you
to
can.
interrupt you. I'm going to let you finish up in rebuttal because your time is up.
Okay,
on the
40,
argument,
40,
okay?
49 to the record, all of a sudden, even when you talk about taking the fraud to a whole nother level, he included all these other defendants, which were never defendants of IGS
Okay,
Realties.
Again, I'm going to let you address that on
Thank you.
rebuttal if you wish. Thank you.
Thank you, Your Honor.
May it please the court, my name is Gregory Scheinlin. I represent the respondent IGS Realty. The arguments made by Mr. Brady have been filed, litigated, and ruled as baseless and frivolous by federal trial courts, federal appellate courts, New York State trial courts, and this is another attempt for another bite at the same apple. It's one of the reasons why in our brief we request that sanctions be imposed. They have been imposed by the trial courts, the federal trial courts, the federal appellate courts. I think it's appropriate here because the same arguments are being submitted even though the party has been informed over and over again that they are without merit. I do not know if the sanctions will alter his behavior, but at the very least, it should make the respondent whole because it's unfair that he has to keep expending resources in order to fight the same claims over and over again.
Thank you.
Thank you.
Your Honor, that's part of the same script that he keeps giving. I'm the one protected by res judicata collateral estoppel, and I need to be protected by this court. And you defend your own decisions. This court never found and couldn't have found that the personal guarantees were enforceable because it was not on the jury sheet. And he just goes through that same script, but there's nothing that ever says that. Gregory Scheinlin is Judge Judy's Scheinlin's stepson, and she's very powerful, and it's amazing how people will make false claims for him. People have repeated his script. Oh, the jury ruled against him and against your counterclaims, and you know that's not true, okay? And I want to point out to you also, he does acknowledge now for the first time that Robert Foss, he distanced himself in this brief. I wasn't there, as Mr. Brady knows, but so they were litigating two different meetings at the same time, and that.
We're familiar with
Okay.
the arguments and the briefs, and we'll look at them.
But just to
No,
mention to
counsel-
you. Okay, thank you, Your Honor.
First, thank you very much. Rodriguez versus 167 LLC.
Afternoon, Your Honors. May it please the court, Joshua Black on behalf of the appellant. Every lawyer knows that you generally
Just
start.
get closer to the microphone. I'm having a little trouble.
Sorry, is this better?
Yes, thank you.
So Joshua Black on behalf of the appellant. May it please the court. Every lawyer knows that you generally start with your strongest argument, especially when that argument is likely to grab the court's attention. However, there is an issue that I'd like to discuss before getting to the issue of whether trial court's trial counsel was ambushed at trial, and that's the summary judgment motion and its interplay with Aho and Bonds-Carr. There is no dispute before this court whether or not plaintiff should have been granted summary judgment on the facts. This response brief does not attack that. Instead, what they say is that basically this court should dismiss that appeal from the summary judgment motion under Aho and under Bonds-Carr. But that's not what those cases say. Bondscar should not preclude a party from obtaining review of an order when appealed separately from the order from a judgment. It was not intended to create a two-tiered system that depends on speed, whereas here, there's a pending appeal when the trial occurs. Nothing in either case says you lose the right of review that you had. And in fact, the appellate level in Bondscar reviewed the summary judgment appeal. I'm sorry, the intermediate appellate court reviewed in Bondscar the summary judgment appeal. Earlier today, while preparing for this case, I found a case from the 4th Department. I provided to counsel, I provided to your honors. It's Bauman versus Bauman. It's 83rd, 1312. It's a 4th Department case from earlier this year that looked at Bondscar, looked at Aho. It involved multiple appeals based on, in fact, that one had 4 appeals. And what it did is the 4th Department followed Bondscar, it followed Aho, and it looked at the merits of the summary judgment motion. Specifically, I'm referring, it's on the 2nd page, to appeal number 3 in that case.
Could I turn your attention to the trial for a moment?
Sure, absolutely.
Could you address the fact that the judge gave leeway to counsel when cross-examining Mr. Morales because he had said a different super had been on duty at that time?
Yeah, so I mean, the trial court absolutely tried to limit the damage as much as possible. But what we had here is a trial by ambush that we know was a trial by ambush because during closing, what defense counsel said is, this is the way that when I was questioning the plaintiff's partner, that's why I questioned him. And so that was multiple days in advance. And then she waited till the very end, presented this witness, adds to the last witness with no prior notice that he was going to change his testimony, and the witness gave the testimony. So sure, the trial judge, we're now, 8 days approximately into the trial? And so she does the trial.
Was there cross-examination on that issue?
On which issue, Your Honor?
The change of testimony or the change of position?
There was, Your Honor, yes.
So the jury heard that?
The jury heard it, absolutely. But again, we're dealing with trial by ambush. So what the trial court said is that what trial counsel should have done is she should have acted differently. He should have done further investigation. But what trial counsel did is he relied upon the sworn statements where there was no ambiguity. It wasn't, I think, but maybe. It was, this is how it occurred. And then the other people who testified during the deposition said the same thing. They said, this is who the super was. And so why should trial counsel disbelieve everything and go, you know what? I'm going to get further records to prove what everybody's already said. That's just not reasonable. So yes, they tried to limit it, but it wasn't sufficient because this was trial by ambush. And this wasn't the only thing. This is obviously the most blatant. The superintendent's changed testimony about, the changed testimony about who the superintendent was that day. But there were additional trial by ambush that further shows that this was not a lone event. We also have the Facebook photos. We also have the Google Maps. And we also have the medical evidence. And so what this shows is this was a part of a course of conduct. So yes, I'm not blaming the trial court in any way saying that it should have acted differently. But what should have happened is the trial court should have said, this is trial by ambush. It should have either directed verdict or precluded the testimony as a whole.
Thank you.
If you have no further questions.
Good afternoon, Your Honors. My name is Andrea Camacho. I represent the respondent defendants, and I was the trial attorney on this case, so I'm intimately familiar with the facts of the case.
Let me just pull it back to how your adversary started their argument on the timeliness issue. The notice of appeal was filed on January 11, 2024, but the appeal was not perfected until October 9, 2024, coincidentally, the same day that the verdict was handed down, albeit by 3 hours, with the verdict proceeding.
No, the notice of appeal was after the verdict. That's what was so frustrating about it. They perfected this appeal with no reference to the verdict. What happened was my firm took the case over at trial. We had nothing to do with summary judgment motion. We didn't realize that nobody filed the decision with notice of entry, which then extended their time to file. After the decision came in, they filed the decision on the motion for summary judgment and tried to perfect it before the appeal on the motion to set aside the verdict. They appealed the verdict and then they withdrew it. If you look at the procedure, they filed appeals, they withdrew appeals till we get to the point that they actually perfected the motion for summary judgment before they perfected the motion to set aside the verdict. But the issue on Ajo is that the trial court found an issue of fact. There were no dispositive motions. There were no claims that were taken outside of the jury's consideration. So that jury, on the question of fact on notice and negligence, went to the jury, and the jury found there was no negligence. So now to try to perfect that appeal without reference to the entire record was we actually made a motion to dismiss it because we felt that it had to be decided together, because once you see it together.
To today.
I'm sorry?
We deferred to today. We deferred the motion to today rather than deciding
Right.
the motion independently. We're
combine
just
the
going to
both.
decide it as part of this proceeding.
Right. And now
You're
we know-
arguing it's a non-final order and we should not address the summary judgment because it wasn't really deciding anything, and under our current state of the law, we should not be considering it at this point. We should only be considering the appeal of the jury verdict.
Correct. And on the issue of trial by ambush, I mean, they can say it 1,000 times. It doesn't make it correct. There was a witness who made a mistake at his deposition, never saw his deposition testimony. In preparation for his trial testimony, said, I was wrong. The identity of the super on that day was this person. I reviewed the records. I was wrong that day. There is nothing in the records to suggest that he intentionally lied.
Yeah, they had an opportunity to bring this out to the jury, didn't they?
Not only that, Judge, but if you go to page, I think it is 1034 of the record, you will see that they actually had a transcript from that witness from another case they handled against my client, wherein he identified a different super. So they were on notice that there was an issue as to when these supers changed hands, because there were several in a short period of time. So, did you have a question? I'm sorry.
Go ahead.
So when this issue came up, Mr. Subin grabbed a transcript that he had on his desk from another trial on another slip and fall or trip and fall at the building and said, hey, you remember giving this sworn testimony? And if you go, we had a whole conversation about it, and he was allowed to cross-examine him. And Mr. Subin took the position that the witness intentionally lied to the jury. That's what he argued to the
Was the
jury.
witness ever sent a copy of his deposition testimony to review and sign off on?
It may have been sent to prior counsel. I can't say, I have no knowledge of whether.
You didn't have a copy of the deposition transcript that was signed by him?
I had it when I prepped him before trial, and I asked him to look through the files and give me specific dates as to who worked when, and then he came back to me with, I made a mistake. But he testified at trial that he was personally never given a copy of it to review in that 60-day period. Which, and there is no
When you
obligation.
reviewed it with him, did you have a copy signed by him?
It wasn't signed by him, no.
that's
It
what I
was
was
just
asking.
a copy of the transcript.
okay,
It was
that's
not
what I was
signed by him, no. And there's no legal, statutory case law precedent that somebody has to put the other side on notice when a witness has made a mistake and it's going to change their testimony. I mean, could you imagine that any mistrial, any motion to set aside a verdict because you weren't on notice that a witness was going to change his testimony? It all goes to credibility. It goes to the jury, and it goes to the weight of the evidence, not the admissibility of it.
Thank you very much.
I'm glad that she mentioned what Mr. Subin did with that other transcript. So what we have here is we have a witness who lies, right?
I'm sorry, did plaintiff's counsel ever send a copy of the deposition transcript to this witness to sign and review? To review and sign, sorry.
I'm not sure. I was just looking at the summary judgment, and it just has an X where the signature would
Right,
be.
but it's,
So I'm-
it's
I-
the, it's the, it's the party who requested the deposition who has the duty or opportunity to send a copy of it to the witness so that they can sign off on whether everything's correct. And if you never did that, then it seems to me to increase the likelihood that somebody would say at trial, oh, that transcript isn't right. But if you never did that, that seems to me it's a problem for you.
But what we're dealing with isn't someone who says that it's a mistranscription. What we're dealing with is someone who says one thing, and then it says something
But
completely
that's why
opposite as
people
to
are sent their transcripts, so that they can say, oh, shoot, I made a mistake. I said plaintiff instead of defendant. I said whatever instead of whatever. People, that happens all the time.
Sure.
And they put in an explanation, but if you never sent them a copy of the deposition transcript, then you're in a poor position to complain about it.
So I don't know based on the appellate record whether or not this happened. And I know it's not a great answer, but it's the truthful answer. But
I
I don't,
appreciate your candor.
but I don't think that that sinks our argument. Because again, what we know is that he has completely changed his testimony as to the key fact, as to whether or not there was evidence to support constructive notice. And we know that in the past, he has lied on this issue. And what we know is defense counsel, when she began questioning the plaintiff's partner, specifically asked questions about who the superintendent was. And we know this based on what she said when she began her closing statement. And if I could just finish because I'm out of time. And what we know is that he then changed his testimony as to this key fact. It's not a question of was the car blue or was it, slightly off. This is one of those key facts that should have been and was asked directly and answered directly.
Thank you.
Thank you, Your Honors.
Owens versus New Empire Corp.
Good morning, Your Honors. I represent the appellants on this appeal, and this appeal arises out of the trial court's fundamental error in which the court denied our motion to dismiss based upon CPLR 3211A7 and A1. The court's decision, simply put, it stated that the denial was based on the one sentence, and that sentence was that the pleadings are liberally construed. Well, that may be true.
One of the issues you raise, is it not, that they haven't adequately pled piercing the corporate veil? Why haven't they? I mean, they've set forth this interlocking group of employees, and every corporation has the same people working in it, that stripped out the funds from the sponsor so that the sponsor wouldn't be able to pay on any judgment. Why isn't that enough on a pleading motion to sustain the cause of action?
Your Honor, I'm glad you asked that. To your point, piercing the corporate veil requires very specific allegations showing wrongdoing by the corporation or its entities or the individuals connected to.
So is siphoning the money out so that there isn't enough money left to pay whatever obligations there are, isn't that enough of a showing of wrongdoing?
Well, that's a very conclusory allegation. Certainly anyone can make such blanket statement, but according to case law, that's not good enough. There's no certain date affiliated with this alleged transaction in which the sponsor siphoned the monies away from the building to where. It doesn't even say where. So in that sense, I would argue that it is conclusory. Second, even if, the complaint ultimately alleges that the basis for its alter ego claim to pierce the corporate veil is that the entities and the individuals share the same office address, and that individuals from company A are also part of Company B. Okay, well, how has that caused harm?
Isn't the real issue here not that they have the same officers or directors or same people, but that when the co-op first started, or kind of first started, there was funds, and then by the time the control period ended, there were no more funds when a lawsuit was brought. So why isn't that sufficient to at least state a claim for piercing the corporate veil based on there being no more funds left during that very relevant time period?
Sure. The sponsor control period is not over. It is still currently the sponsor control period. To your question about siphoning the money, well, the complaint doesn't specifically allege who's doing the siphoning of the money, how much money.
But it's saying that at the beginning, the sponsor had funds, and by the time the control period ended, the sponsor was judgment-proof and there were no longer any funds. Does it really matter where the funds went? The fact that all these interlocking people controlled all of the different entities, and the funds were stripped from the sponsor. That is the allegation.
Well, there's no allegation that.
Now they're judgment-proof, so if it's ultimately found that the sponsor is responsible for the conditions in the building, there's no assets from which to collect a judgment.
Well, there's no specific allegation that the building funds are depleted, and the complaint does acknowledge that.
Sponsors' funds, right?
I'm sorry?
The sponsors. Anyway, go ahead.
The sponsor control period is still active. So we are still in the sponsor control period. But regardless, the complaint alleges these allegations about piercing the corporate veil and corporate wrongdoing based upon information and belief. There's no clear answer as to what that is based on.
Is there a judgment at this point?
There is no judgment at this point.
Judgment.
The building was first occupied in late 2022. So the sponsor control
Says
period.
what you just said, that the sponsor remains in control of the building and it's managing or still in charge, and that there are funds to keep this running?
Correct. The plaintiffs are still living in the building. The sponsor is still in control of appointing the board members.
What the plaintiffs are saying is that if they ultimately get a judgment, the money is going to be gone.
Well, I don't want to make that assumption. It's very unclear to me because
Is that their claim?
one of their claims is that the money is being siphoned. That's all I received from my reading of the complaint.
Thank you.
Good afternoon. The decision by Judge Adams,
Just identify yourself.
Lee Bergstein for the respondent. The decision by Judge
So
Adams
what do you
grants,
say supports piercing the corporate veil here?
well, Your Honor pointed out part of the argument, but just part of the argument, which is
Well,
consistent.
that's the question to him, but now we're up to you. I mean, the fact that the fact that three different corporations all share employees does not mean anything, does it?
It goes beyond that. This is the perfect example of domination by a developer over not just the sponsor, which then dominated the board via a sponsor-controlled board.
Well, the sponsor dominating the board is not an unusual factor, and there's a period of control in which the sponsor is controlled. So that's really, in terms of anything, a meaningless fact.
What is unusual is the sponsor entity is comprised of a single member, Bentley Zhao, who's a defendant in this lawsuit, who's a board member. The developer, the parent company of the sponsor, installed the principles of its parent company onto the board. And it's clear from the allegations in the complaint and the rest of the record that—
Well, since they're going to maintain control of the board during the period which they're permitted to maintain control, who should they put in?
Well,
They're not going to put in the people they're selling to, because that means they're surrendering control, which they're not required to do under the offering plan.
Sure, that's one of the things that we're looking for, given the various harms in the building. But I agree with you. They are going to put in principles that are familiar to the sponsor entity, which in this case are the principles.
And not only that, they presented an offering plan in which they said that these people that they're putting in have fiduciary duty.
But what's the fraud that you're saying is being done? It's not enough to have interlocking officers, directors control. You have to show that something was done as a result of that was fraudulent or wrong, because normally we respect the corporate form. So what are your allegations to support here?
So the
that a
record
wrong
is,
was
the
performed?
record sets forth two separate acts of wrongdoing. Not necessarily fraud, but the appellate division has said wrongdoing is enough in the context of piercing the corporate veil. The first, the court already alluded to, which is taking steps to siphon away assets so that they would render itself judgment-proof, which the court in Baby Fat found was sufficient at the pre-answer phase to sustain pleadings in the context of a motion to dismiss. The second is far more straight.
Does there need to be more specificity in that as to when that happened, where the money went, as your adversary indicates?
Well, the court has also said that this is a fact-laden exercise, and this is a pre-answer motion to dismiss where there was no discovery available. So some of the facts that we wish we had weren't yet available. But aside from that, there is a
You mean
more
you hope that you're going to discover facts which show that the siphoning off funds in order to make the sponsor judgment-proof?
Well, additional facts, but were already facts in the record that support that position. The second piece of evidence, which is
Specifically?
that over the course of the life of the disputed issue here, the sponsor was taking steps to extend the investigation by the consortium of unit owners who were looking into the damage to their building by making false representations about their ability to cure or remediate the various defects.
Did they delay making these repairs until all the units were sold?
They were delaying making the repairs. They were attempting to delay until all the units were sold, and then this lawsuit was brought. So that's set forth in great detail in the complaint, in various letters that are part of the record, and the affirmation of one of the owners. But the second piece that I want to make sure I get to before my time runs out is New Empire, which is the parent company, which is the developer here, is developing a condo right next door. And it used its control over the board, and this is set forth in the record, to grant the developer next door unbridled access to my client's building, the condominium at issue, without an access agreement, without protections, without compensation. They invaded this building because the sponsor-controlled board, at the behest of the developer, permitted them to do so, where typically, as this court knows, an access agreement giving various protections to the owners would have been in place. That's a very specific allegation of wrongdoing, where the use of the board was perverted to permit this unbridled access to the condominium building for the sole benefit of the developer.
Can you tell us which paragraphs in the complaint you allege, that you claim essentially allege sufficient facts for us to support a finding of piercing the corporate veil?
So with respect to the complaint, I have to go back to the complaint itself. With respect to the last allegation that I just made with respect to the building next door, that's in page 542 and 604 of the record.
522?
542 and 604 of the record describes the steps that the developer took to ensure that the building next door had unbridled access to my client's building, where they invaded various terraces, other units in the building for the sole benefit of the developer. With respect to the complaint, there's a piercing the corporate veil section, which sets forth in detail the various inextricably linked entities that were used to abuse the corporate form to the detriment of my client.
Thank you.
Thank you.
John versus Maria, you? No, you didn't ask for rebuttal time, so, yeah.
May it please the court, my name is Richard Min. I represent Ms. Sweat Urqueta in this case involving jurisdictional issues and improper process and rulings on the substantive issues regarding a child, the countries of Chile and the United States, in a case involving the child abduction of a minor. Now, the main issue in this case that we see is one of service or lack of service. The court on March 23rd had its initial appearance after signing an ordered show cause on March 20th, 2023, authorizing...
Let me ask you a question before we go any further. Is there any affidavit from the mother in which she ever denies that she was personally served?
There's no affidavit, no, Your Honor. Again, the
So
burden...
she doesn't address it one way or another how she was served. It's just Are you relying on the fact that there's no affidavit in the record of service?
Well, not simply that there's no
Right, but
affidavit of
let me just say,
service.
there's no affidavit of service in the record, right?
There is none.
So we
and
can
there's-
only go by what the judge ordered to have happen. Go ahead.
Right. I mean, there's no affidavit of service, but that's not the only bit of evidence that we're relying on, because there are transcripts and there's court proceedings that discuss what the procedural history was, which is on March 20th, 2023, the judge issued an order show cause authorizing email service and service through the U.S. Central Authority, which is a requirement under the Inter-American Convention.
Just to stop you on the email service, are there any steps required before email service is allowed?
Well, you need to attempt service traditionally. Personal service, which is what the judge directed on the record on March 23rd, 3 days after signing that initial order to show cause.
I'm sorry, the order to show cause itself did not say anything about attempting personal service, but she did it on the record later?
Yes. So March 20th,
No, I'm sorry, after she signed the order to show cause, she directed personal service?
yes, in the transcript. So March,
Do we have that transcript in front of us?
we do now, yes.
No.
But not
In the
we,
record in front of
the
us.
appellate court.
Yes, it was uploaded to the first department.
It was what?
Is it part of the record?
It was not part of the record. We
Okay.
did not have it at the
Should it
time.
have been part of the record?
It should have been part of the record, Your Honor. We, again,
Just because we can only decide this appeal based on the record we have before us, and we don't have anything in the record about the judge discussing personal service or how to serve, other than what's in the order to show cause.
understood, Your Honor. The first department did reach out asking us to supplement the record with some transcripts, which we did. So those were uploaded, including the March 23rd, 2023 appearance, which we were unaware of at the time. So that which directed personal service, then later on,
How did that happen? Who was present? What happened?
it was ex parte, only the father's attorney was present, and the father's attorney acknowledged that this was a
Did the court
temporary...
order personal service?
Yes.
So it
On
didn't
the
say
record.
it ordered that it basically overruled its order to show cause and
Seemingly.
said service must be by personal service?
Seemingly, Your Honor. And again, the order show cause
Is there any
stated...
written order?
There's no written order, which is why we weren't aware of this, but the order show cause, which again, wasn't just email service, it was email service and service through the U.S. Central Authority, which is a part of
Actually, it
the...
said initiation of service. It didn't say completion of service.
You're right, Your Honor, and I
You-
apologize. I
you're
wanna-
s- I just want to understand this because this is not information that any of us had. You're saying that the court subsequently said, I'm not going to follow what I said in the order to show cause. In fact, you have to do personal service?
I mean, the court didn't say I'm not going to follow, I want to be very clear, the court didn't say I'm not going to follow what I previously signed, but the court
The effect of it
specifically...
was that. That was the effect of it.
Effectively, the court made several statements in that transcript, such as, you have to go to Chile, we don't have jurisdiction, I'm directing personal jurisdiction. They said the father's trying to bootstrap jurisdiction here in New York where it doesn't belong. So there are
When did
many
we get these
comments.
transcripts? How did they get sent to the court?
They were uploaded, I believe, on Monday, Your Honor.
This Monday?
Yes, Your Honor. And again, we were not aware of this. The first department reached out asking us for these specific transcripts, which we
Has
were not aware of.
anybody
And
made a request for additional briefing based on these transcripts?
clerk's office only called to ask that we provide these transcripts, which we did.
Because they should have been part of the record to start with.
Of course, I agree. I agree. And as we were not attorneys at the time, we were not aware of these. And frankly, throughout the entirety of the proceedings, these dates never came up in terms of
So
being transcripts. Yeah.
to
Yes, Your Honor.
to the extent that the judge issued an order at that time saying there had to be personal service in Chile, I don't see anything in the record constituting an affidavit of service by person, of affidavit of personal service on the mother.
So this
Am I
is-
missing something?
No, this is where it gets quite strange because the next...
Well, just answer, let's start with an answer. Is there an affidavit of personal service on the mother?
There is not.
Okay.
Okay. And then on the following date, April 11th, 2023, with no real explanation, the judge accepts the attempts of personal service, the two affidavit of attempted service, and acknowledges that service is complete and accepts the attempted and accepts the prior email service. Doesn't order future alternate service.
So there was no, the affidavit said, I tried to make service and didn't, and the other affidavit said, I made service by email.
No, there were, so there are two
The
attempts.
judge does that on April 11th because the mother doesn't show, because on April 10th, the mother had been emailed a link in order to join proceedings, but she doesn't.
That is what was represented. Obviously, my client is not a native English speaker, barely speaks English, frankly. And so, you know, this is why service through proper diplomatic channels, such as the Inter-American Convention on Letters Rogatory, are super important in these types of cases, and not to go willy-nilly with email service or attempted service as valid service. But that's just part of the puzzle here, Your Honors, because
If you're serving through the international, Inter-American conventions, what's that process?
so again, the order show cause said the right first step, which was presumably prepared by counsel, which is to initiate service through the U.S. Central Authority, which then gets sent to the Chilean Central Authority. This is on the U.S. Department of State and Department of Justice websites in terms of the process. So the process is to go through the government channels, which is seemingly what the judge understood and recognized at the beginning, what counsel for the father recognized at the beginning, yet there's no explanation in the record where that went. There's no explanation of how that failed, if at all.
Let me go back a minute to this updated transcript. This transcript where the court supposedly changes the method of service, was that transcript so ordered? Did it actually become an, so it's not even an order of the court, it's just something she said?
Yes, she directed
So it's not really, that can't be an order if she never so ordered it, or?
I
It's
agree.
just something she said. So basically, that sounds like, and I'm going to obviously ask counsel for the other side, but basically, we're still legally analyzing it the way it was initially presented to us, which is whether the initial service in the order to show cause was or was not a valid method of service for the court to order.
And the judge also said in that transcript that she demanded proof that the father file appropriate papers in the appropriate court in the country of Chile. That is the place he must file. And then she warned that without proof that he did that on the next court date, she would dismiss the case with prejudice immediately.
And that was what day, March 23rd?
March 23rd, 2023.
But then when they come back in April,
It's like
as
it
if
never
that
happened.
never happened.
Exactly.
Was any of that brought up in the briefing, though, in this case? Like, neither side brought any of this up. You
again-
didn't have it, but the other side didn't bring it up in the briefing either.
No one brought it. We were not obviously attorneys of record at the time. We were not even aware that this proceeding occurred with this, with any detail until the first department clearly had notice or some information that there's a proceeding on this date, which is when we ordered the transcript.
Okay,
We only found out about this
Let's hear
on
from
Monday.
opposing counsel and see what they have to say.
Yes, Your Honor, I'd like to reserve
Maybe
issue
we'll
on
get some more
jurisdiction.
clarity.
May it please the court, Patricia Firsch for the respondent. Whoops,
We
sorry.
don't usually have oral argument by ambush, which is what this one is feeling like right now. But can you first address this issue of what the court maybe said during a subsequent hearing, and whether that was ever embodied in an order, and why it wasn't addressed in the briefing?
Well, can I
There's
just,
a lot of questions, but
can I try to just explain what actually occurred? So on March 23rd, my colleague Merrill Haft appeared before Judge Lupoloff, and the record that Mr. Min made regarding Judge Lupoloff's remarks at that time differed from what was actually written as the service on the order to show cause, on the order.
Was March 23rd the same day that the order to show cause was signed?
No, the order to show cause, Your Honor, I believe was signed on March 20th,
Okay, so this is 3 days later.
3 days later.
Do you have the transcript of what happened on March 23rd?
I do only
But
because,
why was it not included in the record before?
no, Your Honor, only because of what Mr. Min,
Wait, why wasn't it included in the record?
we didn't submit the record, appellant submitted the record, and frankly,
I just want to
Go ahead.
get straight exactly what's going on. So you didn't submit it, but how come then, if it sounds like the court said there should be a different method of service, and that's a whole issue in this case, so why didn't you address it at all in the briefing in this appeal?
respectfully, Your Honor, I think we simply addressed what Mr. what appellant had raised on behalf of the mother, which was that she wasn't served.
So is your position, because I think counsel's position, from what I can understand, is that this, whatever the judge said during this appearance, she never so ordered that transcript, so it's not even really actually an order. What's your position as to how we should be evaluating this? Should we be evaluating it based on the way that it was initially presented to us, and the issue being whether that service as ordered in the order to show cause was valid?
That is our position, Your Honor.
Okay, so I think both sides are basically, from what I understand, agreeing then that the way we should evaluate is the way that it was presented to us, and that later transcript doesn't really change how we should evaluate. Is that correct?
That would be correct, Your Honor, because what I believe occurred, if Judge Gessler, I'm sorry, Justice Gessler.
Just have her answer. I just want to hear her answer to that.
Sorry. I thought she had.
So what I believe occurred on March 23rd was that the judge did not realize that it was an order to show cause being brought under the UCC JEA as asking the court to exert emergency jurisdiction. I believe the court read it as if it was a modification petition. Hence, the court's commentary about personal service and also comments about filing in Chile. When I appeared on April 11th.
Let's not get to that, because
Okay.
let's go.
Sorry, Your Honor.
Because we both, if we're saying that that didn't really change anything, the analysis isn't about what happened at that subsequent hearing, then we do have a number of questions about that initial order to show cause. And first, whether that was even a valid method for the court to order that service be effectuated, because normally, if you're going to do email or some alternate method of service, you first have to show that there was some attempt to do personal service, and that was impractical, and therefore you could go to the next level of service. And it does not appear, at least in this record as presented to us, that any such showing was made in this case. Can you address that?
Any such showing as to
It was
personal.
made that the personal service was impractical, and therefore that it was okay to do some alternate method of service other than the typical personal service that is typically required.
The
There was
court
no
is correct.
affidavit, right?
No application was made for substituted service. We did attempt personal service. We did initiate service through the central authority, and we did
Was this after the order to show cause, though, or before the order to show cause?
after the order to
Because
show
the
cause.
question for us legally is, at least initially, whether the court's order was appropriate in terms of the type of service that the court ordered. So anything that you did after that court ordered that type of service doesn't really answer the initial question of whether the order was even appropriate in the first instance in terms of what was being ordered.
So I don't believe that the Inter-American Convention requires requires personal service.
Well, I disagree with you.
Okay.
Let's assume that it does require, as our law requires, that service to be done either by personal service or by mail in a form of mail that requires a receipt. And that something alternate can only be authorized by a court if the party seeking the service has shown that those were impractical. Am I correct that you did not show, at the time you presented the order to show cause, that it was impractical to make service either personally or by mail?
We did not know it at that time, Your Honor. So the answer is no, we did not. No.
Okay, so
I don't understand. You didn't know what?
We didn't know that the mother essentially lives in a bunker, if you will, that no one could really, that service was going to be extremely, if nothing else, impossible.
Okay, so let's go past the first question, which is whether the court erred in the way that it provided that service should be done without first requiring an attempt at personal service. The next issue then, even if the court didn't err, the question would be whether there ever was appropriate service. Is there any dispute in this matter that she never was personally served?
It is disputed, Your Honor,
Where's
because
the affidavit of personal service?
there is no affidavit of personal service.
And without referencing whatever acknowledgement you think was made in another case, outside of that, is there anything in the record that would show that she was personally served?
There is nothing in the record that would show that. But the mother acknowledged as,
That's never been enough. I mean, you know that that's never been enough under the law. The issue in service cases is never whether the person had awareness of it. It's always that to get personal jurisdiction over someone, you have to serve in accordance with either the CPLR or the Family Court Act or whatever act it is that you're looking at. The fact that they may have had some awareness is just not germane to the determination the court has to
she
make.
was served in accordance with what the court directed on the order to show cause.
Where is an affidavit of service showing that she was served in accordance with what the court ordered?
I believe
And
it's,
then when you say in accordance with what the court ordered, if the court orders email service and that's not appropriate without several things happening before then, I think it brings you back to my colleague's question that the court erred in the first place.
well, that may be so. However, there are affidavits of service on the mother alleging or acknowledging or affirming, rather, that she was served by email and that the service through the central authority had been
Is
commenced.
there a need for a hearing to establish the record in this case?
I don't think I understand your question.
Is there a need
Justice
to have a
Ginsburg.
hearing to establish whether or not she was served? Because there is no affidavit of service, and you say that she was served, and I'm not questioning what you say, but in terms of the record in front of us, is there a need for further proceedings to establish this?
Well, I think as a practical matter, the child's been here 3 years.
We need to address jurisdiction before we get to that.
I'm sorry, what's the question before me?
Whether there
Justice
should be a
Friedman.
hearing to establish that there's been service in this case.
That may be so, Your Honor.
So when you say there was proof of service, you mean there was proof of personal service?
No, Your Honor,
Okay, and so the
no,
proof of service you're claiming is that there was proof that she was served by email.
correct, Your Honor.
Okay, so we have a question about whether or not that would be legal service.
I understand
And
that.
you also claim that there was proof that you initiated service with the international agency that does service, but there's no part of the process they go through is to then create an affidavit of service once they've completed it. So you have the affidavit of initiating the process, but nothing from them showing that their agency, through its methods, made service on her, correct?
That's correct, Your Honor.
Okay.
Any further questions from the bench? Okay, thank you.
Thank you, Your Honor.
Good afternoon. Lawyers for Children on behalf of...
Can you bring the microphone down?
Sure. Hi. Shreem Nothenberg, Lawyers for Children on behalf of the child SBS.
So I read through your brief, and I was a little, I don't know, I guess the question that I have for you is, you, as the attorney for the child, you were not responsible for the service in this?
No, not at all.
Case, right? It was the respondent who was responsible for it, and your brief seems to make reference that the service was proper because of the email service that took place. And as you've heard that we've discussed here for quite some time now, I'm just wondering, do you have anything else to add beyond that?
If I could, that would be terrific. What I'd like to do is walk through. It was, the first motion was brought, the order to show cause by definition is an emergency. So in every order to show cause that I have at least filed in the family court, I have asked that there be email service in addition to, and then at some point to...
But as a matter of law, a judge is...
Go ahead. Go ahead.
Go ahead.
But as a matter of law, a judge is not allowed to order email service unless there's been a showing that
There's an
personal
emergency.
service or mail service.
Well, no, for the order to show cause,
Excuse me. As I read the statute, a judge is not supposed to order email service unless service in person or by mail is impractical. So if that's what you're seeking, then you need an affidavit showing that. And are you aware that there was any such affidavit anywhere?
No, but I'm aware that the argument being made within the order show cause was that there was an emergent situation in which personal service might not have been timely, so the request was to make it by email and then make it also
What statutory
start the...
authority do you have for that?
I'm sorry?
What statutory authority do you have? What statute, either in the Family Court Act or the CPLR or anywhere, says that in that kind of situation, it alters the requirements as to what kind of service is required to obtain personal jurisdiction where the mother lives in Chile and it's undisputed she lives in Chile? What's the legal authority for
The
that?
legal authority would be 308 and 311, which does allow for alternate service if you do have a reason, a
The
need
reason,
be,
so
the
308 and
expedition-
311, even assuming that applies, and arguably it doesn't under these circumstances because of the international situation, but even assuming it applies, 308 and 311 are very clear that you cannot do an alternate method of service unless you make a showing that you attempted personal service and you could not achieve that personal service. So where does 308 or 311 give support for your argument that you can do an alternate email method of service without first attempting some other type of regular type of service?
You're absolutely right. The showing was not that they had attempted. It was just that it would be to get the emergent relief they needed, they couldn't.
But where does the statute, I mean, because I've looked at, I know 308 and 311, and there's nothing in there about an emergency situation. You can bypass the first few provisions and go straight to email service.
That's where we'd have to rest it, because it was an emergent situation in which the father was seeking.
So is it your position that in emergency situations, the CPLR and the proper avenues of service
It's my
do not
reading
matter?
of it- It's my reading of it that that is a barrier to personal service when you're seeking emergent relief. A barrier could be.
But I mean, I guess the question would follow that there would need to be some really significant showing that it was a barrier, and just because this person lived in Chile was not enough. And you as the attorney for a child, I don't even know how you can stand here and argue that position because you're not responsible for service. That's what the respondent is responsible for. And according to what was heard here today, they didn't even know where she lived in a rural place. They found that out later. So I'm not sure what you're basing your argument on.
What I would base my argument on is the relief. I'm representing the child and as desirous of having that emergent relief ordered, I certainly would have, I'm certainly arguing in favor that service was proper because I believe, well, first of all, the court just ordered it. The court ordered it and they complied with it. And then ultimately they did serve her. Mom admitted under oath that she was personally served on April 11th.
Did she admit that in the context of the Hague proceeding or in some other context?
In the Hague proceeding.
Thank you.
Thank you.
Your Honor,
If we agree with you that the service as made before this proceeding was not adequate, would it be appropriate for us to dismiss the proceeding, to remand it for a traverse hearing, or to remand it to vacate the default order but start over with the pleading from the time of before the default motion was made? What are you suggesting is the appropriate remedy? Because I have to admit, I'm finding that troublesome.
sure. At the very least, the orders issued by the court must be vacated.
The default orders.
The default orders, of course. At the end of the day, the father filed a petition in March 2023 after the child had only been in the United States for approximately 3 months at that point in time.
Right, but in addition to vacating the default orders, are you asking us to do anything else? And if so, what?
Well, ultimately, the petition itself has significant problems, which we believe should be dismissed. And so I want to sort of get to that, and whether the court does that.
Time's up, but what did you specifically, and we will look at the record more carefully, but what did you specifically ask for in this appeal? You clearly asked that the default order be vacated, but did you ask for any additional relief on this appeal other than the default order be vacated?
Well, we did ask for dismissal, and that's the denial of the motion to dismiss is why we're here.
For lack of jurisdiction.
For lack of jurisdiction and lack of subject matter jurisdiction. I really quickly want to hit on that, because the request the father made was for temporary emergency jurisdiction under the guise of a modification petition in the UCCJA. There was no temporary emergency jurisdiction because we can get into the facts, but the district court found the child was not suicidal. But putting that aside, what the court issued was a final change in custody, not a temporary emergency
Right, but if we
jurisdiction order.
vacate the default, we would not get to any of those issues.
Right.
We'd just be vacant.
Yeah.
You have another
The-
question?
No, I
before
was
we
just
start?
going to say, did you want to address the home state issue?
Yes, well, because, I mean, ultimately, in order to modify, you need home state and you need certain other factors. Number one, New York was not the home state
Counsel,
when the
if
petition was
if
filed.
we grant the motion to vacate, we wouldn't be deciding that issue right now, right?
Well, we are asking for dismissal of the petition.
Because you say there's a lack of subject matter jurisdiction.
Yes, Your Honor.
But the court never ruled on that below, right? Did the court below make any ruling
Well, is the,
on whether or not there was or was not subject matter jurisdiction?
Well, we raised it in our motion, and they denied our motion, so I understand Your Honor's question, but I do feel like they did rule on it because that was the subject of our motion, or one of the subjects of our motion, and they denied our motion.
You're saying the issue is there, but it wasn't ruled on.
I think they started the
Implicitly,
issue,
it was
so
ruled
maybe-
on? I think implicitly?
So what you're saying is it was implicitly ruled on because it went forward, because it denied your whole motion, and that was one branch of it.
Yes.
and because custody changed. Did custody change?
Custody did change, but that was before, of course, we filed our motion and dismissed. That was on default. And again, when the father asked for temporary
So
emergency
if the default is vacated, what happens with that part of the default motion?
what happens with that part of our motion?
Right, if we vacate the default orders based upon all the things that we've said here and service and things of that nature, where the court issued a ruling inside that default motion, what happens with that?
Well, I mean, our motion to dismiss, we would either refile or want to be reinstated because our motion to dismiss is on subject matter jurisdiction grounds, and we would then ask the court to make specific rulings on that.
If the court doesn't have, if we find that service was improper in this case, and there was never personal jurisdiction obtained over your client, then we shouldn't be making any substantive rulings, should we? Because we're finding that the court never acquired jurisdiction over her to be making rulings about the case.
Your Honor makes an excellent point, and I understand Your Honor's point, but at the end of the day, I think the appellate court is empowered with addressing the issues that have been addressed by the court and by...
Are you not that the record, are you also saying that the record establishes that New York was not her place of residence, and therefore New York lacks subject matter jurisdiction? It's either in Minnesota or Chile, but it's not in New York.
Entirely
That's
accurate.
your argument.
That is entirely our argument, Your Honor. And again, the procedural history is quite clear. The father asked for temporary emergency jurisdiction. The court granted a change
Would it
in
also
custody.
be your position that we shouldn't even get to the we don't need to get to the personal jurisdiction issue because the record establishes that there's no subject matter jurisdiction?
Well, I think there's a lot of available options to the court here. And so I am not suggesting one approach versus the other. I think we have many ways in which the court can rule
I
that
wasn't
in our
suggesting the
favor.
approach, that's your position is my question.
Right, if you decide on the subject matter jurisdiction issue, then it sort of renders null and void, or renders meaningless the other issues, I guess, because the action sort of disappears, right? But if Your Honors take the approach of simply addressing the personal jurisdiction issue and the service issue and voids the default orders, then it sort of takes us back to square one, which is a petition filed in March 2023, and on that date of petition, did jurisdiction lie
You wouldn't be
in New York
totally unhappy with that either.
I would not, because then we would file another motion to dismiss stating that in March 2023, there was no jurisdiction in the state of New York.
So going back to Ms. Fursh's question about practicality, if we were to dismiss it, the entire proceeding, which it seems to me is the result that your argument goes toward, then there's a child in limbo. We don't like to leave children in limbo. So that's a problem. I mean,
Yes.
do you have any thoughts about that?
Well, yes, but again, that's why we have the UCCJA, Your Honor, and that's why we have custody orders in Chile, in Minnesota, and the appropriate jurisdictional issues should be addressed. Unfortunately, and I don't think it's the fault of anybody necessarily, but unfortunately, the laws are the way they are, and we've been dealing with this for the last 2 years plus, both in the Hague Convention and federal courts and in this court, Minnesota and Chile. And ultimately, my client and I'm sure the father both have a vested interest in seeing what's best for the child, but we do
Thank
have
you.
to deal with the
Thank you.
jurisdictional issues first, Your Honor.
Thank you.
Thank you.
United Medicine Rehabilitation.
Good afternoon, Your Honors. My name is Joseph Altman. I represent the appellant on this appeal, seeking to reverse the decision and order of Justice Barbado. When you review the order, decision and order, as well as the record on appeal, conspicuous by its absence is any mention of the statutory condition precedent, which is good cause to permit the late filing of the expert disclosure, which was done by the plaintiff a few days before trial. The plaintiff, prior to filing of the notice issue, ignored any attempt to provide the expert disclosure. There was a PC order, there was a CC order, and there was also a motion to strike from the calendar where the plaintiff indicated that this matter was ready for trial. So all these things were completely ignored, and then apparently a few days before this matter was to go to trial, 8 days, after 2.5 years, the plaintiff served the expert disclosure. I would imagine to surprise the defendant, who thought for all these years that there was not going to be any expert disclosure on this matter.
But hadn't they raised that they wanted to have,
Well,
intended to have an accountant or something, a business valuation expert?
you could say 2 years. They mentioned that when they hired one in response to my notice to produce information about their expert witness, they said they were going to let us know.
Right.
Okay, but you can't file and serve a note of issue.
Didn't they say they were actually going to hire one 3 years earlier?
I don't know if they were.
And that they would let you know when they did?
I don't know if they said they were actually going to do it. However, you need to provide good cause.
But didn't the judge actually give time? Like it wasn't, you didn't go to trial right then. It was months later for you to be able to get your own expert.
Then how do you get around the good cause requirement? The judge should have said, what was your good cause? Just like he ignored the good cause in the statute when the respondent submitted his respondent's brief on page 3 of his brief, he completely ignored that. I could understand if he had good cause, he was sick, the expert reports got lost, something. But in reality, they hired a different attorney after the action was on trial, was ready to go to trial. They hired a different attorney, and they came up with another theory of what they wanted to do. Hiring another attorney is not good cause, and that's really what it was.
We're familiar with the briefs and the arguments. Thank you.
Can I just say one more thing?
No, thank you.
Okay, thank you.
Solomon versus 360 East 72nd.
May it please the court, Joe Said for the plaintiff appellant. In this case, the court dismissed the complaint, imposed sanctions in multiple times, threatened further sanctions, and restricted access to the court for what he labeled baseless smears in opinions without findings or citations that consumed 4 typed pages, all after a single oral argument, despite our multiple requests, according to his rules for such argument. This case, first order in this case, said it appears to be not in dispute that the issues underlying this action were raised in an ongoing civil court proceeding. He's absolutely wrong. My brief was devoted in part, large part, to that section. My brief is in the record at pages 103 to 105. We pointed this out to him multiple times in letters and in subsequent motions. He never changed his finding. And the case went downhill from there. Every time I tried to point out that it was just an error and that he could correct it, he got madder and madder, which led to not only the sanctions award with no written findings according with the rule, but which forbid me from applying for any further motions without his leave, a so-called gatekeeper order. Now, I've researched as best I could. I could not find a single New York case in which a practicing lawyer representing a client was ever issued that kind of order. And he ordered it after a single motion that I filed, a motion for recusal. He made it clear that people seeking recusal in his court were going to be punished. I asked.
Did he use that word? Did he use that word?
No, but that's the consequence of what he did. It was the only motion I filed, and he found it contained baseless smears, which it did not. My briefs were 7 pages long. You can read them. I think they're good briefs. I don't think they cross the line. I have no idea why he thought there were baseless smears. I think he made it very clear that the case, if remanded, should not go to him, but should go to a different judge. As best I can tell, he was angry that I kept pointing out that apparently his staff had screwed up. And he got madder and madder as I tried to get him to make a simple change. As far as race judicata and collateral estoppel, there is absolutely no doubt there was no final judgment in the prior case. And
You have time for rebuttal. Thank you.
Good afternoon, Your Honors. Emil Saman for the respondents. Your Honors, this is a basic case. The civil court action that Mr. Saeed started years ago has been going on for years. After some issues with the caption and his service, we made a summary judgment motion to dismiss. It was granted in part, denied in part. 2 of the parties were dismissed from the case, and multiple causes of action were dismissed. Instead of appealing that, then Mr. Saeed started the Supreme Court action, which basically had the same facts, the same set of circumstances, the same transaction, the same parties, and added the parties back in that had previously dismissed, and the only difference was he jacked up the damages. We made a motion to dismiss that complaint. The judge granted our motion. He also issued sanctions for a frivolous action, and Mr. Saeed then asked him to recuse himself based on the fact that he said that there was some relationship with our client, one of the client, the board president, who's a law professor. That motion was denied, and additional sanctions were issued for us having to defend against that motion. And that's basically it. Thank you.
We're not asking for a reassignment to a different judge because we disagreed with his rulings. He did far more than rule against me. Every time there was a contested issue, he totally ignored every single paper I submitted. You can look at his orders and compare them with my briefs, and you can see that he didn't even read the briefs. He admitted that in the first opinion. There is no written record explaining why he imposed sanctions. Absolutely nothing. It's just 4 pages of typing that included 3 rulings. Uh, uh,
Thank you.
he,
Thank you. Your time is up. Thank you very much. People versus Moultrie.
Good afternoon, and may it please the court. On behalf of Mr. Carl Moultrie, the Legal Aid Society by Norma Esquivel. This case is about the police deputizing parole officers to investigate a vague, anonymous tip about Mr. Moultrie's brother, Christian, possessing a gun. By searching Mr. Moultrie's bedroom for evidence
So
of
why
this...
wasn't this otherwise within the purview of what a parole officer is entitled to do with regard to somebody on parole?
The reason for why this was not something that the parole officer here could do, and this is specifically about Mr. Carl Moultrie, not his brother, is because intrinsic to the examination as to whether there is sufficient suspicion to conduct a parole search is whether...
Why does there have to be sufficient suspicion to have a parole search? Isn't the whole point of it that a patrol officer can go look at any time to see if the person is complying?
No, Your Honor, and the reason not is because there are cases like People versus Candelaria and People versus Huntley, which set forth the examination or the analysis under which it must be determined whether or not the police officer's actions are reasonably and rationally related to their parole officer's duties.
Well, counsel, just to take a step back, did this defendant consent to searches as part of his parole?
He did sign a certificate.
And then, okay, and so then in the Candelaria case, it might be a little bit more distinguishable, right? Because in that particular case, the police officer was aware of domestic violence, called the parole officer specifically about this domestic violence, had the wife then report the domestic violence to the parole officer, and we don't have any of that here. I mean, I can go on because it gets worse in Candelaria, but we don't have that here. We have the alert that there is some contraband at this residence where a parolee lives, and then the parole officer in their duties goes and conducts a search. Does a safety search or something like that, which is rationally related to the things that they're allowed to do.
Well, for a couple of points, Your Honor. So first, Candelaria is a little different. It's about searching for evidence of a murder, searching for the gun that was used in a murder. Here, the way that there is a parallel between those cases where there is no rational or reasonable basis is also the fact that Huntley and Lively make clear that it's not just a rational and reasonable basis, it also has to include whether there is substantial connection to the particular circumstances. And the reason why that's critical here is because the tip was not specific, it was not about the general residence, it was about his brother Christian. And that is demonstrated.
But they're staying in the same apartment, aren't they?
Yes, and it is
And
quite.
they're both on parole.
Correct. But I think that the record
And if the
here,
brother has a gun in the apartment, that's a problem for the defendant too, is it not?
well, I think again, what needs to be analyzed here is exactly what the tip is about. So the tip is about Christian, and may I also add that one of the
Of a domestic violence incident involving a firearm.
No, Your Honor. So my understanding is that the I card is for a DV strangulation involving Christian, Mr. Moultrie's brother, and that there was a report about a gun. Now, there is a disconnect as to whether it was in the residence or whether it was specific to Christian, because one of the reasons why Mr. Moultrie was offered a more favorable plea was because the tip was about his brother, and that is on page 5 of the plea transcripts. So again, it is tailored specifically to Christian, and the fact
What happens when there's a search conducted and there's a weapon found and there are multiple people who reside in that residence? What happens then?
Well, I think what happens then obviously is whether or not there was any sort of suspicion involving the person whose area they searched. And that's specifically why. So for example, the reason why they asked
This
for
was
photos-
found in a common area in a living room?
While it is a living room, it was functionally Mr. Moultrie's bedroom, and there is ample evidence that it was Mr. Moultrie's bedroom. In fact, the very reason why they looped in Mr. Moultrie's parole officer was so they could
That if a parole officer gets a report that that someone who's one of his parolees is in an apartment with another individual and that there's a gun in the apartment, they're not permitted to search?
Well, again, I think it's not that they're not permitted to search, Your
I
Honor.
think you're approaching this what you might expect of the police in terms of what they can do of arresting a suspect. But we're dealing with the parolee here, and there's definitely a tip that there might be a gun in that apartment.
Well, just to briefly conclude, Your Honor, just because there is a potential anonymous, vague, uncorroborated tip does not mean that a parole officer has a wholesale carte blanche ability to search a parolee's residence. That would run afoul
That
of-
came from the consent though, right?
Well, it came with the consent, but then again, Your Honor, there are cases like People versus Johnson, People versus Andrews, and People versus Campbell, People versus Nappy. All of those cases involved parole searches that were ultimately deemed lawful. But part of the analysis was about whether or not there was some sort of corroboration. So, for example, in Johnson, Andrews, and Campbell, the parole officer witnessed the violation firsthand, either independently viewing a video of a robbery, or in People versus Nappy, where the parole officer was given a tip by somebody's, I believe it was mother, and also in People versus McMillan, where they were, again, receiving tips from someone that was identifiable.
Thank you. Do you have any other questions, bench? Thank you very much.
Good afternoon, Your Honors. Jacob Marcus for the People.
To pick up on your colleague's last point, doesn't the tip come from Detective Zapula?
The tip does come from Detective Zappala, but as both the Court of Appeals and this court have acknowledged, the fact that the basis to search originates with law enforcement doesn't bear on whether the parole officers conducted a parole search for legitimate parole purposes.
Did the defendant agree not to have firearms and also agree to allow parole officers to search his residence?
Yes, he did. He both consented to searches and agreed not to possess firearms. And that's what makes this case sharply distinguishable from McMillan. McMillan was concerned with a police officer's intrusion on a parolee's Fourth Amendment rights. But as the court in McMillan noted, this case is different because the basis is both the consent that informs the parole officer's duties as well as their diminished expectation of privacy. With regard to the reasonable relation to Justice Friedman's point, this is a parole officer who received a tip that there was a gun in the apartment. Page 6 of the record, the report is not that Christian Moultrie possessed a gun, it's that there was a firearm in the apartment. Because of that, the officers were duty-bound to investigate, and their search proceeded completely by the book after that point. And then to the Candelaria agents of the police issue, I'll just note to Justice Pitt-Burke's point that we are really worlds away from what has been held unlawful in Candelaria. Here, the police, although initially were involved in the initial tip, or relaying the initial tip, I should say, and also ultimately arrested defendant after the gun was discovered. They weren't involved in conferencing the case. They weren't involved in planning the search. They weren't involved in executing the search. So for those reasons, and I'll also note that defendant waived his right to appeal in a pretty ironclad appeal colloquy. So for those reasons, we ask that you affirm.
Thank you.
Very quickly, Your Honors. So number one, McMillan is applicable because it's not, the police intrusion is not analyzed under the police standard, it's analyzed under the Huntley standard for parole officers. And what was important to the court there was the fact that detective was working with a joint parole task force. So again, Huntley does apply, or excuse me, McMillan does apply here where there is some semblance of individualized suspicion that justifies the search. And with regard to the waiver of appeal, the waiver here is not valid for two reasons. One is that the court failed to explain that appellate rights, how they are separate and distinct from trial rights. The court did not specify that that it is not something that is automatically waived upon any plea of guilty. And the second reason for why it's not valid is because he executed the written waiver of appeal prior to the colloquy with the court. And this would put someone in a
We've
position.
held that that doesn't invalidate the waiver, haven't we?
That is correct, Your Honor.
Several occasions.
But this, well, the reason I bring this up is because of the cumulative effect. So here, for example, someone like Mr. Moultrie, who is a layperson, might think that he can't take this plea back, or that he couldn't have, for example, negotiated a plea that didn't involve a waiver of appeal.
Thank you very much.
Thank you.
Brigade Cavalry Fund versus Sharika.
Good afternoon, Your Honors. Doug Jensen on behalf of appellants. My colleague, Mr. Goodnow, was admitted pro hac vice in August, and I would request permission for him to handle the argument. Thank you.
Thank you. Well, good afternoon, and may it please the court. My name is Chris Goodnow, and I'm here on behalf of defendant appellant Kieran McGrath.
Counsel, why shouldn't we just continue the stay that we granted in the motion to this court, which seemed to make a lot of sense to me, that we just stay discovery until the federal court gets an opportunity to rule on whether discovery should be stayed in this action pending the motion of the determination of the federal motion to dismiss?
Yes, Your Honor, we think that's, exactly right and exactly where I was going to start, that in September, this court stayed discovery of this
Why
action.
not just continue that?
Yeah, exactly. That would be what our request for relief is. Indeed, this
That's
appeal.
what you're asking for.
Yes, yeah, this appeal always asks for the exact same relief that this court actually
You weren't also asking for us to stay pending the federal court deciding the motion that's pending in federal court?
I guess maybe then I should be precise here, because in federal court right now, there is one motion that is pending, which is the motion to dismiss that Mr. McGrath filed and has been before the court.
Isn't there also pending a motion to stay discovery in this action until the motion to dismiss is decided?
So we also sought, when the trial court below started discovery, we went to the federal judge and filed a letter seeking leave to file a motion under SLUSA, the Securities Litigation Uniform Standards Act, for the judge there to issue a stay. So the only relief we asked for in our motion for stay pending appeal and here is a stay pending resolution of the motion to dismiss, which is how we interpreted the court's order.
Sorry, now I'm getting confused, because I thought the way we decided the motion that was submitted to this court is to stay this case just until the federal court determined your letter application to stay until they make a determination on the stay of discovery. And you just initially said to me you agreed with that, but now I think I'm hearing something different from you. So I feel like I'm hearing inconsistent things from you.
Yeah, and it's perhaps because...
Are you happy if we issue an order saying that discovery is stayed in this action until the federal court makes a determination on the motion to stay discovery? Or are you seeking a stay until the federal motion to dismiss is decided?
We would be happy.
Either one.
But either one, quite frankly, we would be happy if the court extended its prior motion. The request that we made was for a stay pending resolution of the federal motion to dismiss.
But you wouldn't have any objection if we did the first one?
There's certainly no objection if that was the way that the court preferred to proceed. But the reason why we asked for, both in our motion for stay pending appeal and now on appeal, the stay pending resolution of the federal motion to dismiss is because that is how Judge Gardefee already ruled a year ago what the best path forward was for these cases. And we think as a matter of comedy, this court is supposed to defer to the judgment of the first filed federal action and conduct these cases in the way
It's
that...
the same action.
Well, if there's a substantial
I
identity
mean, there's certainly
between...
an argument being made that it's not the same action.
Well, it does. So it's not the fact that it's the same action. It's the fact is whether there's a substantial identity between the cases, whether they arise from the same subject matter. And they certainly do. We think this court at least implicitly decided that when it issued the stay previously. Judge Gardefee in New York recognized that the cases were related. He actually called them as such, and that's Record 125. When this case was in North Carolina, Judge Conrad stayed discovery, recognizing that the cases were related as well. So we think the argument that the cases are not related has failed several times, and that's because it's not meritorious. These cases arise out of the same operative nucleus of facts. They both challenge forward-looking statements made by Avaya on or around May 10th, 2022, and they both rely on the exact same evidence, internal Avaya emails for the most part, showing that these forward-looking statements were allegedly false and allegedly made with scienter. So the difference between these cases as far as the underlying facts that they rely on, they're quite closely related, and that's why every court to look at that issue has reached that same conclusion. So we do think the cases are related, and then the question becomes, as a matter of the comedy analysis, does discovery in this case interfere with the federal case? And we think the answer to that question is yes.
Can I ask you one last question? Is the federal court going to decide that letter application? Is it currently pending there?
The letter application is pending before the court. When this
There
court
will be a
issued,
determination at some point on that letter application.
so when this court issued its stay, we informed the federal court that it had issued the stay. So if this court now were to extend the stay pending resolution of our SLUSA request specifically, we would go back to the court and inform the judge of the most recent order.
Okay. Thank you.
Thank you.
Good afternoon, Your Honors. May it please the court. Maeve O'Connor for the brigade funds.
So let me ask you the same exact question.
I-
Why shouldn't we just continue the stay that we already issued on the motion? Doesn't that make sense that the federal court should get the first shot at deciding whether discovery in this action should be stayed, pending their determination on whether discovery in this action should be stayed?
I would say no, Your Honor, for several reasons. First of all, much as my colleague wants to make these cases the same, they're not the same because Mr. McGrath personally, in private conversations, defrauded my clients and personally through a certification of solvency.
I just want to interrupt because I feel like that's jumping the gun a little. I'm happy for you to address that issue, but shouldn't we first address the procedural posture that we're in? And my specific question about waiting for the federal, since that very question is before the federal court, shouldn't we let the federal court decide it first before we go ahead?
Well, I guess I was trying to answer it, I guess, the way I would see it, which is the fact that they put the question before the federal court doesn't mean it has any merit. It doesn't mean these claims are related, and it doesn't mean that our case is similar or subsumed within the class. He's got a very broad...
Okay, so then what's wrong with what counsel is saying, that it's the underlying misrepresentation that's being sued on, that's the heart of both actions, is the same in both actions. So why isn't they're obviously not identical actions, but why isn't there a significant overlap between the state and the federal action that would justify us granting the stay we previously issued?
Because we have different claims that are adjudicated under different standards. It's a little bit, I hear the argument as I should be protected by the enormity of my fraud from having to do discovery in any of the matters because there's a lot of matters. And that to me is not, I think, a fair way to look at it because of the fact that Mr. McGrath personally defrauded our client in a way that is not ever going to be adjudicated in federal court. He certified the company was solvent in order to get us to put in much needed funds. 2 weeks later, the company filed for bankruptcy.
But didn't the federal, I guess, legislature make a decision based on their issuing the special act and special stays of discovery in these type of actions that we should at least give some comedy deference to before stepping our feet into the waters here in terms of how discovery should proceed in these actions, particularly where it's ultimately the same fund that's going to satisfy all of these obligations?
I don't agree with that, Your Honor. I don't think that's a correct representation of what the federal legislature has done. And I think Judge Gardefee very clearly explained it in his order that the fact that the PSLRA stays discovery in a federal securities action subject to the PSLRA and does not stay discovery in this case is not evidence of undue prejudice at all. It's evidence of Congress's view that a PSLRA case under the federal securities laws is different. The whole point of that was to avoid strike suits, which were a big problem, and so this statute came in and said plaintiffs in this type of case aren't going to get discovery until they have a case that survives a motion. It was never to protect Mr. McGrath. That's never been what the PSLRA was for. SLUSA, they're taking a long shot asking Judge Gardefee to stay this case under SLUSA, exercising his discretion. That is extremely rarely ever done. This is a very unusual ask.
But the court has the authority to do that. I mean, in a normal case, the court would not have the authority to stay discovering a state court action, but here they do have that authority to make that determination.
They have the authority, but they've also had this before them for 5 months and obviously have not thought that.
Right, but since they do specifically have that authority, why not give them a chance to decide how to exercise that authority before we make a determination, which seems to be what we were thinking when we initially granted the motion, although we don't actually give decisions on that.
I guess I would submit that Judge Gardefee has had an opportunity for 5 months to say, let's have a pre-motion conference and see whether I'm interested in hearing this motion or not.
He also hasn't decided the motion to dismiss, right?
Exactly, but meanwhile, we're stuck and we have claims that need to be litigated independently. No matter what happens in that case, they could win their motion to dismiss, this case proceeds. Because we have independent claims, we have unique claims that cost us $100 million, Mr. McGrath's fraud on us, not on a class. These are not market statements. These have nothing to do with the New York Stock Exchange price. These are harms inflicted upon us by Mr. McGrath, who is not entitled, I would submit, under any federal or state law to stay our prosecution of these claims any further. There's no principle of New York law that protects him by the enormity of his fraud from having to answer to this. There's no principle of New York law that says that he's not required to have discovery go forward on a case that is
All right, but
different.
I guess I'm repeating the question somewhat, but doesn't the federal statute allow the federal court to stay discovering this action if it desires to do so?
It allows it to do that if it decides to do so, but I guess what I would say to the court is the New York State Court is not required to cease exercising its jurisdiction and just wait and see whether Judge Gardefee feels like doing that. The standard is not met. This case is independent. This case is different. Our claims are unique. These claims will go forward no matter what. So no matter what he decides, and that's why I guess I would say it's just a very long shot motion. He's not going to, Judge Gardefee is not going to say that our claims can't proceed because the class case is not about the ways in which Mr. McGrath defrauded
Can't
Brigade.
guess how the federal court's going to rule, though, obviously.
I
don't know how the federal court's going to rule in the motion.
I understand that, but I guess all of this is sort of, in my view, it's let me throw out a bunch of federal statutes and let me suggest that this case is the same. It is plainly not the same, and I think that's all this court needs to understand. It's plainly not the same.
Thank you, Your Honors. Just a couple of points in a brief rebuttal.
What about the point that it's been 5 months, the court hasn't addressed it? She's making a strong argument that they're not exactly the same claims. Why should we stay discovery in this state court action, which is going to go forward no matter what?
So a couple of responses, Your Honor. Judge Gardefee in New York has already indicated how he thinks these cases should proceed, that there is a limited directors and officers insurance fund, and it's unfair and prejudicial to the federal plaintiffs for state court plaintiffs to get a jump on that fund. And so what is the equitable result here is a stay across all of the cases. He already said that in June of 2024, and so when counsel says that it's a long shot motion under SLUSA, I think we actually already know what Judge Gardefee thinks because he's told that more than a year ago. As far as to the passage of time, from June of 2024 until May, the case remained stayed, as he anticipated. There was a brief period in which there was discovery, in which the parties were negotiating discovery but didn't produce documents yet. And then in September, this court imposed a discovery stay. So there's not been this huge lapse of time in which Judge Gardefee has not done anything.
Thank you.
Okay, thank you, Your Honor.
Thank you. Windermere Properties versus City of New York.
Good afternoon, Your Honors. May it please the Court, for the appellant, Rosenberg and Estes PC by Alex Estes as appellate counsel. I appear before you today to seek the Court's guidance on essentially two threshold issues in this Article 78 proceeding. The first is the denial of the petitioner's Article 78 proceeding, which was which was denied on a sua sponte issued of res judicata raised by the lower court.
Nobody made that argument to the judge, right? That it should be dismissed on res judicata grounds?
No, it was actually never raised at all, Your Honor. On the motion to renew, the motion was denied with no oral argument without addressing the merits. I actually submit, based on this court's authority, specifically in the First Mercury versus Nova case and the Hernandez v. New York City Housing Court Authority, which is on page 16 of our moving brief, that renewal should have been granted and the merits would have been addressed.
Let me ask you, let's say res judicata should not have been raised by the court sua sponte and res judicata doesn't apply because these are different claims. they, were not even, a decision was not even made on them at the time the prior decision was made, and res judicata is not an issue. Why doesn't the same underlying legal reasoning, though, for which the court dismissed the other cases, also ultimately are going to result in a decision in this case that the claim should be dismissed on the merits?
Well, thank you for asking, Your Honor. The reason being
My
is
pleasure.
the reason being is that the denial was for a completely different set of circumstance and decision. In the first Article 78 proceeding, the denial of the motions to vacate the default at oath were based on our client did not meet the requisite circumstances, the exceptional circumstances, that is the bar at oath to open the default. The violations that are before the court in the instant Article 78 were not denied on those grounds. Don't even mention those grounds.
I guess my question is a practical one,
Oh, I'm sorry.
which is that ultimately, even if it goes down to be heard on the merits again, let's say we agree with you that, the court, they only denied it on the ground that the fee was already paid, and that's not the correct procedure, and it goes back down on the merits. Why would there be any other different results in this case about the exceptional circumstances? What ultimately are you going to get in this case?
Well, at the end of the day, because exceptional circumstances wasn't raised, that shouldn't be an issue. What should procedurally happen, Your Honor, if you agree with everything that I said, and I really am hoping you do, that if it gets then remanded back to oath, it would be for a new hearing on the merits of the violations at issue.
Right, so let's say that all happens.
Yes,
Why wouldn't it be the same exact determination on the merits as the prior proceeding?
because it wasn't determined on the merits in the prior proceeding. A hearing never happened on the first set of violations. What happened in the first proceeding was there were
The court found
defaults.
no exceptional circumstances, right?
Right, but that was to vacate the default in the hearing.
Do the procedures of these hearings permit for any sort of negotiation between the respondent and you over what fine might be paid? Is there a possibility of compromise on this when it goes back down, or?
Does the statute permit that? No, but practically, Your Honor, it does happen.
It does happen.
It does happen.
So if it gets vacated and sent back for a new hearing, there's the possibility of you being able to resolve it with the respondents.
Absolutely, and I know my client would be more than willing to engage in a conversation to resolve those fines, Your Honor. Yes, absolutely. And so to address Your Honor's point, if it does get remanded, it would be for a hearing on the merits. I just want to make sure I'm clear, and forgive me if I'm not. The determinations in the first proceeding, it never even went to a hearing on the merits of the summonses themselves, because all the summons very differ on what they were actually issued for. The issue was there was a default. Did we meet the grounds to vacate the default and have a hearing? That was the sole issue. And the violations before us, it was also for motions to vacate a default, so we can actually argue the merits of the actual summonses that we are subject to here. But because the motions were denied for default for completely different reasons, unrelated to the first proceeding, even though these violations were not issued, the decisions were not issued at the time of the first proceeding, it should go to oath for the actual hearing. I can't believe this is actually happening, but I'm actually good on time right now, unless Your Honors have any further questions.
No.
I'd like to reserve my right for rebuttal if Your Honors have any further questions. Thank you.
Good afternoon, Your Honors. May it please the court, Shane Magnetti for oath. Windermere has already litigated the merits of its law office failure excuse in a prior proceeding. Supreme Court dismissed it, and this court...
It seems that it's undisputed that the summonses that were at issue in the prior proceeding are not the same summonses that were issued in this proceeding. And our prior ruling, where we affirmed the determination, were not concerning the 13 summonses that issue in this case. So, and you've acknowledged that in your papers. So that being the case, how could res judicata possibly apply in this action to bar this particular case?
Res judicata applies here because if you look at the transactional approach that this court applies when considering res judicata, you will see that these are 40 identical motions supported by identical proof, seeking the same...
Let me get to what feels like the big problem here, that the reason that these summonses were denied was a different reason than all the other summonses were denied. So the only reason this summons is, the vacating of the default was denied was on the ground that there had already been a payment, which was, again, a completely different ground than all the other summonses. So it's a different legal issue that we as a court now have to address, because don't we have to address the actual ground that was given for the denial of the motion to vacate, which was the payment of the fees, the fine?
It's a different legal issue, yes. They were decided on different grounds, but that's not dispositive of the res
Don't we have
judicata
to,
analysis.
don't we, because it's a completely different legal issue, they never had an opportunity to ever argue before that the determination to deny it on the ground that the fines were already paid was affected by an error of law. That's a completely novel argument that never got to be presented with respect to any of the other summonses, right?
That's true, but again, I think
Why shouldn't we then address that argument? Because how could it be res judicata if it was never even raised before? And could not have been raised before because these were the only summonses where that issue was raised as a basis for denial.
Because, Your Honor, I think the key inquiry here is whether or not these claims form a convenient trial unit. And in order to determine that, you look to the motions themselves, which are the same facts for every single
Right, but
motion.
a different denial.
But just under oath, do you ever give a defaulting party an opportunity to vacate when the fines have been paid? In this case, they were not paid voluntarily, they were taken after a judgment.
I don't believe so, Your Honor. I think the default itself is considered as an admission of liability. So too is the receipt of payment.
But if you take the money pursuing enforcing a judgment, the person has never had an opportunity to come in and state their claims with regard to these particular summonses. The idea that all the motions are exactly the same, aren't all these tickets often exactly the same?
Well, I think
Aren't
if you
what,
look at
what
these
you issue
summonses-
exactly, they're all unique?
Well, just a few points in response. So it's not that Windermere never had an opportunity to address these summonses. They defaulted. They never showed up over the course of 10 years. They defaulted on over 40 summonses here. Now, to the extent you disagree with me on my res judicata argument, I think the remedy here is not just to remand for new hearings here. If you look at the statute, 621F, there has to be a showing of exceptional circumstances for them to get a new hearing in the first place.
Counsel, don't we only have the ability to look at what was alleged was the basis for denying the motion to vacate the default? And the only basis alleged here for denying the motion to vacate the default was that the fines were already paid. There was no other basis alleged. So how do we have the ability as a court then to go beyond the administrative record and address an argument that wasn't previously raised?
That's not what I'm asking you to do, Your Honor. If you don't...
How do we get to the issue of exceptional circumstances where the only basis for denial of these particular summonses was that the fines were already paid?
You don't have to do that here. If you disagree with the res judicata analysis, I think you could remand this case to Supreme Court to address the merits of the waiver argument, whether or not payment was an admission of liability, and let them address that issue in the first instance, as this court routinely does when it finds that Supreme Court has incorrectly dismissed an Article 78 proceeding for an alternative reason.
Thank you. Let's hear from opposing counsel's response.
Thank you.
Thank you, Your Honor. I could be very brief on this issue. The first thing, with respect to remand the Supreme Court, what's before this court is not just the motion to renew, but also the ultimate denial of the petition. And going to that, we can address the actual merits, which Your Honor had pointed out is correct. It's a very narrow scope in the administrative record. And with respect to the fines being paid, my adversary said that they're deemed an admission. It's when there is a voluntary payment where I pay to you the fine. I am thus admitting because instead of a hearing, I'm admitting and paying. That's not what happened here. The fines were paid not because we voluntarily paid, but the marshal levied our client's accounts as a result of a default judgment. Since the denial of the motions was solely because on the fact that the fines were paid and you were deemed admitted it, we believe it's arbitrary and capricious to say that because we did not voluntarily make the payment. And specifically, 48 RCNY 621H, which is another subsection in what my adversary had cited, actually provides for that fines can be refunded if a motion to vacate a default is granted, if oath so does so. So I would just like to submit that the statutory framework in which oath operates has a mechanism that provides for motions to vacate default to be granted in the event fines were paid beforehand. And I would thus ask this court to not just grant renewal, but to also grant the petition in its entirety. And with that, I would like to thank this court for its time and guidance, and I wish you all a wonderful day. Thank you so much.
Thank you. TD Bank versus AH Dental.
May it please the court, good afternoon. My name is Michael Leinoff from Lebanon Kaufman for Dr. Heifetz and AH Dental. Your Honors, this case involves three key issues coming off of a summary judgment motion, appealing from a summary judgment motion, in which it is our position the summary judgment motion was granted prematurely. This is a pre-discovery summary judgment motion carrying issues that the evidentiary formalities were not met, that a certain defense of failure to mitigate was not followed, and that the element of the interest rate was not fully established. To begin, the appellants argued below that
Counsel, these were promissory notes. We get a lot of these kind of cases.
Absolutely.
They were executed, they weren't paid.
Absolutely.
What's missing in this case? What was wrong with the court's determination?
The respondents' arguments were simply a recitation of the elements of breach of contract as it pertains to promissory note, and our response to that was simply that it wasn't fully established.
Was there any
wasn't fully-
affidavit was there an affidavit by anybody with personal knowledge submitted in support of that?
It's a business record affidavit, so it's never expected that in a banking case that someone will have personal knowledge, and we certainly don't expect them to, but we enter it through business records. So it's our argument that...
What was wrong with the showing?
It's our argument that the business record affidavit wasn't perfect as it should be, that there was certain elements missing. I'm sorry?
What was wrong with it?
There were the elements of... that under the Unifund CCR standard, that the how and when the records were created was missing. That it's the contemporaneous element was also outside was also missing from the affidavit itself.
Vice President Cathari says he's, based on personal knowledge, he says these are the documents, right? And they haven't been paid?
There was also an element that said that they were prepared by a person with knowledge, an unspecified person. So under Del Valle v. Sugarman, that an unspecified person is not competent to testify.
But we have the loan documents, right?
I'm sorry?
We have the loan documents, right?
Yes.
And the averment that they haven't been paid.
We have the assertion by the respondent that they haven't been paid. But
Is there anyone saying that they have been paid?
no, we didn't submit an affidavit in response. But as I've often said in the past, that if there were no burden, if there were no evidentiary formalities required to enter documents into the evidence, then we wouldn't need lawyers. The entire purpose of procedure is to make sure that the procedure is completely met. When elements of the procedure are not met, then the prima facie case doesn't exist. There were two other issues that were remaining too, as well. There were outstanding defenses that the defendants raised below. One was a defense that gone through that. One was the defense that the failure to mitigate wasn't met, and the other defense was that the plaintiff failed to set forth the interest rate.
We're familiar with the arguments. We've read the briefs.
Okay.
So we're familiar with all the arguments.
All right, and I
We'll
see that my
consider
time
them
is
all.
up. So,
Thank you.
all right, thanks.
Good afternoon, Your Honors. May it please the court. Robert Mastrogiacomo for the respondent, TD Bank. The case is pretty simple. The court below correctly found that plaintiff established its prima facie case, and that shifted the burden to the defendant. The defendant submitted no affidavit from anybody with personal knowledge to contest any of the facts laid forth to the court with respect to the loans, the documents evidencing the loans, the default on those loans, and the amounts due and owing. The appellant keeps pointing to questions regarding the interest rates and the prime rate. One of the loans, there were two loans involved. One was at a fixed rate, and the other was at a prime rate. However, upon default, both had an interest rate of 18%. There was a fixed default rate of interest. So the prime rate was no longer an issue with respect to calculating the amount of damages. And the court correctly found, based on the documentation submitted, the loan history, the amounts that were due and owing for principal, and he set forth that on that principal amount, interest should be calculated at 18% from the date of default through the entry of judgment, and from that point forward at the statutory rate. And that's exactly what the court entered. They entered a judgment for the principal amount outstanding with interest at the default rate. There was no question, as far as we're concerned, with respect to the affirmant who submitted the affidavit in support. He stated that it was all based on personal knowledge and the review of the books and records of the bank. The fact that he didn't input every book and record of the bank is not unheard of. I mean, he's not supposed to be the person collecting payments and inputting the information into the banking system. That's somebody else to do, and that was done properly, and he relied on those books and records to base his affidavit.
Thank you. Oh, do you have a question?
Yeah, I was just going to say, was there any duty for the bank to mitigate the damages?
Well, with respect to the mitigation question, the bank did begin an action to recover equipment that it had a lien on, but frankly, it wasn't worth the money to go forward with that. And the guarantee itself that the individual guarantor signed said that he waived his right to force the bank to choose any specific method of recovering what was owed. So in other words, the bank could choose how it sought to recover its money. And in this case, while it did start an action to replevy the equipment, it decided that we're going to move for summary judgment as opposed to going after the equipment, which was allowed to do.
Duty to mitigate at that point.
Excuse me?
And under the agreement, you had no duty to mitigate at that point.
No, I mean, we did everything that was reasonable. I mean, we were just trying to collect our monies.
Thank you.
Thank you.
People versus Lewis?
Good afternoon, Your Honors. I'm Hillary Dowling, representing appellant Mr. Leonard Lewis. Mr. Lewis was convicted under federal law, which, unlike New York, has amended and updated its definition of child pornography to include 3 distinct categories. A is traditional child pornography, where the relevant sexual acts are performed by an actual child. B is virtual child pornography, and C is morphed child pornography, which is the images that issues in this case. And those are specifically images that have been altered to appear as though a minor is engaged in sexual.
The penal law that we're looking at here uses the word simulated.
Yes.
And simulated would then be the explicit depiction of sexual conduct, right?
Yes.
Why would these photos not fall within simulation?
So the term simulated is contained within the definition of sexual conduct, and that is the definition that simulation is applied to. And what that means is that when there's relevant sexual acts depicted in something. So for instance, in a sort of typical child pornography case, if there is a child that's depicted having sexual intercourse, it's no defense that that sexual intercourse didn't actually occur. It could be simulated to make a reasonable viewer think that that is happening, but both of those things are obviously criminalized because subjecting a child to simulating or actually having sexual intercourse is still child abuse. So simulated is specifically something that qualifies the sexual conduct, which is why it's contained in that definition. The respondent attempts to take simulated out of that definition and apply it to the child or the statute as a whole. But what New York Penal Law 263-15 actually criminalizes is relevant sexual acts, whether those acts actually occurred or were just simulated, but the relevant sexual acts have to be committed by a child under New York's law, when I was discussing the federal law where Mr. Lewis is guilty because federal law and Congress has expanded the statute to extend beyond traditional child pornography. It's that A, B, and C. New York only has A. New York has
At
not
that time, you're aware that the law has been amended since then?
amended to include
Be parallel to the federal statute?
well, by the adding of the digitization language.
Yeah, the amendment to 263.15.
Yeah, but that doesn't include, well, first, that's not the case before this court.
Right, yes.
But I will,
You don't need to address whether it applies to this case, sorry.
but I will note, though, that that's still not expanding the definition to more of child pornography. And one of those reasons is that the definition of digitization is contained in a revenge porn statute, where the language specifically says it has to be a realistic portrayal, and there's no.
Well, I mean, and we're not going to get into that because if we
Okay.
could go through the legislative history.
Fair enough.
We might have different opinions as to what that particular pertains to. But I just want to bring it back to what's
Simulated.
actually in the statute in terms of simulation. Here we have pictures of children put on bodies of adults,
Correct.
right?
And in one case, a cartoon.
Okay. But engaged in what is sexual conduct.
Correct.
And these were actually distributed, which is very different from some of the cases you might cite where there was a First Amendment issue, where there was only something about possession and those kind of cases. These were actually distributed, sent to the children themselves.
The child, yes.
Yes. And the child, rather, thank you.
Yes.
So I guess I just want to bring it back to, there's a depiction of sexual conduct. These pictures are simulated because they're not the actual child. So we know we're not dealing with actual, but the statute does allow for simulation. I'm just wondering how that is not, under the North standard, something that we can consider. And then why can't we consider the conduct in the federal case, again, under the North standard?
Well, we do have to consider the conduct.
Yes.
I agree with that. So simulated, the construction of simulated that the respondent is trying to use, which again is taking it out of the definition of the sexual conduct, which was again to protect children who are put into these positions, into these performances.
The
There's no
victimization of children, right? So in terms of the child receiving this picture of this simulated conduct with their picture on it, is that not victimization of the child?
Oh, well, so the question isn't here about whether this conduct should be criminalized. The question is whether New York has. So that construction of simulation has actually been directly rejected by the U.S. Supreme Court in U.S. v. Williams, where they were analyzing the federal definition of sexually explicit conduct. In this case, it's sexual conduct, but Justice Thomas specifically said the New York's definition of sexual conduct is the same in terms of that they both include this simulated faction. And he said that he defined simulated sexual conduct as conduct that must be explicitly portrayed, even though it may not have actually occurred, and the portrayal must cause a reasonable viewer to believe that the actors actually engaged in that conduct. So here, we're talking about the sexual conduct of adults. It's irrelevant whether those adults were actually performing sexual acts or not, because New York still has only Category A. They only have Category A, where it says the relevant sexual acts, whether actual or simulated, must be committed by a child. And it's indisputed that that did not happen in this case. It's the New York legislature's responsibility to expand the definition. So again, we're not talking about whether this conduct should be criminalized, because Congress clearly thinks that it does. Several other states clearly think that it does, because they have expanded their child pornography definitions to mimic the federal statute and those three different categories. And 2 states did so, the state of Florida and the state of New Hampshire, which I cite in my brief, that analyzed this exact issue and said, look, we don't like this conduct and we want our legislatures to criminalize it. But as it currently stands, our child pornography statute is just like New York's, which only prohibits images where a child is involved in the production. It has to be the sexual acts, real or simulated, but by a child. The legislature can expand that definition, they just have not done so.
Further questions? Thank you.
Thank you.
Good afternoon. May it please the court, Larry Glasser for the respondent, people of the state of New York.
So, counsel, how do we get around the way the courts, and your adversary just alluded to them, the Parker case, which came out of Florida, the Zidell case that came out of New Hampshire? How do we get around those interpretations?
Well, the way we get around those interpretations is because under North, the appropriate analysis for this court, as Your Honor has said, is not to compare the federal law to the state law. Under North, the first step is to determine if they have similar elements, which defense concedes that they do. You then move to the second step of North, which is to look at whether defendant's conduct violates the New York state law. So it doesn't matter if federal law uses the word morphed or has 3 categories or however the federal law is structured. We compare the defendant's conduct to see if it violates a state law. And as Your Honor said, when you substitute in the definitions, as I note in my brief, the New York State statute criminalizes the explicit depiction of certain things such as sexual intercourse, sexual conduct, or lewd exhibition of the genitals, which creates the appearance of such conduct by a child less than 17 years of age.
But I'm having trouble understanding that. These pictures didn't suggest that the sexual act was being conducted by the child, was being performed by the child. The child's face was pasted onto the face of the adult.
Yes, Your Honor.
Well, engaged in that action. So I'm not condoning the behavior, but I don't understand how it comes within the definition of Penal Law 263.15, which was in effect at that time.
Because it depicted the defendant having sexual intercourse and engaging in these acts with a 16-year-old. The fact that it wasn't photoshopped and well done with high-tech computer software, but instead it was a crude depiction, doesn't make it less of a depiction.
But are you saying that someone looking at that picture would think that it was a child engaging in the sexual acts?
I don't think that that's what needs to be conveyed. It's simulated under the wording of the statute. If you look at the context, if you look at the defendant sending these pictures to the 16-year-old with the comments he was making at the time he was sending them, putting his face on one picture and the child's face on another, he was depicting himself having sex with the child. No one is saying that the child will look at that and wonder if it was him involved, but it was an actual child. It wasn't an AI-generated image or anything like that. It was an actual child. The pictures depicted the pictures contained the depiction of sexual intercourse, and it created the appearance of the conduct by the child. The images appear to show, however crudely, the defendant engaged in sexual intercourse with the child. Much as a movie can depict, as I note in my brief, in an action movie, the star of the movie could get shot or injured. The actual actor is not injured during the filming for the movie to depict the injury happening. Something can be depicted through media, even through paintings or drawings or photographs, without the actual underlying event occurring. And while the federal law calls that morphed, and again, I submit the federal statute is not relevant, the New York law, which prohibits the depiction of not only this conduct, I mean, if there was the actual child involved, that would satisfy Your Honor's question, but that would make creating the appearance of the conduct clause unnecessary. It's logically and it's grammatically.
Well, no, that's not the only way it would satisfy my question. It could be that it was an actual child engaging in simulated sexual acts. That would be what I would think was covered by the statute.
But that would only work for some of the conduct prohibited by the statute. I don't know how you would have an actual conduct, or I'm sorry, an actual child simulating nudity, for example. You either have the simulation of nudity or actual nudity of a child. It doesn't, the statute saying it has to be an actual child, which defendant really puts a lot of stock in, is to protect the First Amendment concerns. And that's what those federal cases address, where it has to be an actual child, an identifiable child. It can't be an adult who appears to be a child. It can't be an AI-generated image of someone who does not exist. This is an actual child. This is the 16-year-old complainant in this case, the victim. The defendant wanted to have sexual intercourse with the victim. He created these images depicting himself having sexual intercourse with the victim. He could have sent the victim the pictures as is and said, just think about it, this could be us. But he put the faces on it and sent it to the victim, depicting him and the victim engaged in this conduct. These pictures violated Penal Law 263-15. He was subject to register in New York.
Thank you.
Thank you.
I'd like to first just correct a misstatement by my adversary. Federal law actually does prohibit all those things he talks about because it has A, B, and C. It prohibits the A, it prohibits the B, which is considered virtual computer-generated images, and it prohibits C, which is what we have here, where the face of a child is superimposed onto the body of adults, but no actual child engaged in the performance depicted. He is guilty under federal law. That is why he was convicted under federal law. He is not currently guilty under 263-15 because New York has not expanded their definition of child pornography to include these other things. The reason Congress expanded the definition is because they found that these new types of things were not covered by traditional child pornography. They didn't just start interpreting it as covering it that. These other courts have also followed suit. I'll also just go back, since we're talking about the simulation issue, I'll just say Justice Thomas continued, it has to be explicitly, again, it's about the conduct, not a simulation of an entire event. He said the portrayal the second part of it, this conduct must be explicitly portrayed even though it may not have actually occurred, and the portrayal must cause a reasonable viewer to believe that the actual actors actually engaged in that conduct. And then he said, although the sexual conduct may be simulated, it must involve actual children. So there's no dispute here that that doesn't qualify. There's no, the federal prosecutors didn't have a reasonable view. So if I can just quickly finish, the state court in Florida quoted that U.S. v. Williams case and said, sorry, it's not gonna work here.
We're familiar with both of the state court cases.
I'm sorry?
We're familiar with both
Okay,
the
thank
state
you.
court cases
Thank you.
and exactly
All
what
right,
they
appreciate
did.
it. Thank you.
Thank you.
Thank you.